So those are the questions I have. But I do have some final comments that I wanted to make. First of all, I appreciate today was very helpful. You know, in some parts it wasn't. Most of it was. It wasn't in a sense that I couldn't get some of my other questions answered, but I understood why that happened. You couldn't answer them, Mr. Walmart. But I just have a general comment, which really relates to process before this commission and the relationship that the company has with this commission, issues of trust. It doesn't really relate to what occurred today, but relates to what led up to today. And I have some notes here that I'm going to follow here, and I think it's very important for the company to listen to this. But the filing was made in November of 2022. And it's apparent that the company knew long before it made its filing that it intended to contract with Landis & Gyr for a substantial amount of the work on a sole source basis. The filing made no mention of the intention to rely so heavily on that one vendor for so much. The only statement that was made by the company in its filing that mentioned sole sourcing was very, very general. It was said, it didn't really, wasn't specific at all. But less than 3 months later, the company entered into some key agreements with Landis & Gyr and didn't disclose that to the commission. When the commission was asking about claims of confidentiality over what appeared at the time to be only estimated costs, the company alluded to non-disclosure commitments, but never disclosed that it had agreements which already committed the company to pricing for some of the fees over which the company sought confidentiality. In fact, on February 17, the company filed a memorandum in support of its motion for confidentiality, and in it, there was the following assertion. The categories of costs for which the company seeks protective treatment contain vendor-specific costs for monthly maintenance fees, operations service fees, and software costs. Revealing this information publicly likely would impact the ability of the company to get best cost pricing in future negotiations and would reveal the confidential information of third-party vendors, close quote. There was no mention of the fact that the company had already had firm commitments under contract for some of the pricing for which the company sought confidential treatment. In fact, the language of the pleading left the clear impression that all costs were still subject to negotiation. It wasn't until extensive questioning took place at the April 14th hearing that it was finally disclosed to this commission that the company had binding agreements with the vendor that went beyond a mere 2-page confidentiality agreement. Even then, the disclosure only occurred because Commissioner Anthony asked a direct question about whether the company had a signed contract with pricing established. We got copies of the agreements. Now, having had the opportunity to review those agreements, let me make this clear to the company. These agreements were not entered into merely in the ordinary course of business. Those agreements related directly to the Commission's inquiry relating to confidentiality of cost figures that were present in the company's filing. The fact that the company did not disclose them to the Commission is completely unacceptable. But even worse, when the Commission was questioning claims for confidentiality about what appeared to be estimated costs, and I spent time issuing written orders to provide clear directives and guidance to the company that provided ample opportunity and time for the company to appeal to the full Commission, the company still continued to hide the existence and general content of those agreements from the Commission. I also went back over the transcript of the April 14 hearings, and it was troubling to say the least. It is one thing to argue for confidentiality where the Commission has access to the data on a confidential basis, and the only question is whether it should be public. But it is quite another when the regulated utility masks the existence of material information relating directly to the request for rate recovery, preventing the Commission from obtaining the information on a timely basis. It appears that the company apparently was okay to dodge disclosure of those binding pricing agreements, other than to make vague assertions regarding an NDA, until it came time for a witness to testify under oath to a direct question. Only then did the company disclose the information. And I don't let counsel for the company off the hook either. At the hearing, When addressing the question whether the vendor's name should be disclosed, I mistakenly assumed during the hearing that the company did not have a binding agreement other than an NDA. Counsel for the company made what appeared to be a clarification, but now I see it as misleading in how it materially omitted important information about the agreements. Specifically, during the hearing, I made the statement, "So I don't think there's a basis, for keeping the vendor's name out. You've made clear that you have no agreement with them yet, so there's no obligation here." Counsel then followed up with this statement, "Mr. Chair, could I just clarify one point? When we said we don't have an agreement in place, that's for the actual purchase of the meters. That agreement is not in place. There's an overarching non-disclosure agreement in place between the vendor and the company. So that agreement is in place, and that's in part what we're relying on as the basis for confidentiality. So I just wanted to clarify that there are a few agreements in place, some of which are final and some of which are not." The company's witness may have later disclosed the details after a precise question was asked, but that is beside the point. This is a regulatory proceeding. It is not civil litigation, where the attorneys might answer questions or instruct their client to answer questions as narrowly as possible, placing the burden on the person asking the questions to ask the question very precisely before a transparent disclosure is required to be made. Practicing before this commission and pursuing approvals before this commission requires candor and transparency. We will accept nothing less from the utility. Rhode Island Energy's first priority should be to this commission, not to the desires of the company's vendor, who stands to charge millions of dollars through the program being funded by ratepayers of this state. Equally important, this is not a case where the company has exercised its management discretion to contract as it sees fit, and then seek rate recovery after the fact, with all the risks inherent in the regulatory review occurring in a rate case. It is a case where the utility is essentially asking this commission to pre-approve its plan in order to obtain what amounts to a virtual guarantee of cost recovery in advance of implementing it, completely avoiding the risk of a rate case. When a utility is asking for rate recovery, the utility has the burden of proof to put on evidence to support its entire case. At this stage, it cannot be said that the company has filed even a prima facie case regarding the reasonableness of the prices already obtained from this single vendor, notwithstanding what happened today in this technical session. Now the company's long resistance relating to confidentiality, which ultimately tripped into the revelations about the contracts, may have placed the current hearing schedule in jeopardy. Counsel for the commission will be in touch with the parties as to what the schedule is going to be doing and what modifications might be necessary. But I had to give that message for you. I do appreciate everyone coming today, but we have a long road ahead. Thank you.
Mr. Chair, may I just respond briefly on behalf of the company?
Go ahead.
Thank you. And I'm sure you can understand, I feel it's necessary to say something in response to that before we close. And I do want to thank you for your comments. I want to speak for myself and for everyone at PPL here that we are certainly listening to your feedback. We are taking it back. We are sharing it with the larger group. And again, speaking for myself and everyone here, I know it is no one's intention here to hide anything from the commission. And so we certainly take your comments, we take them seriously, and I think what we've tried to do here today is to provide the best information we can to help the commission and the other parties and stakeholders do their job to be able to evaluate this proposal, and it is certainly our intent, and we take your message, and we'll continue to try to do that and be as forthcoming as we can and provide the information to this body that it needs to make an appropriate decision. So thank you.
Thank you. I'm sure we'll be seeing you again soon. Thanks.